As stated earlier, the Supreme Court has been assigned by the Constitution a special role as the protector and guarantor of fundamental rights. By the Article 32 is an appropriate case when 32(1) is an appropriate case when the court feels that the investigation by police authority is not a proper direction and the order to the complete justice in the case, and where the high police official are involved in a crime, it is always open to court to hand over the investigation to the independent agency like CBI in order to evoke the jurisdiction under Article 32 approach to the Supreme Court directly. It has to be shown as to why the High Court had not been approached, could not be approached, or it was futile to approach to the High Court. The invocation jurisdiction of the Supreme Court under Article 32 of the Constitution cannot be said appropriate, inappropriate, where the direction was given for the protection of minor child who was illegally removed to India by his mother from a foreign country, and his child was traced through the CBI on the writ petition filed by the father who is a foreign citizen, where therefore the infringement of a fundamental right has been established. The Supreme Court cannot be refused relief under Article 32 on the ground that is the aggrieved person may be the remedy from somewhere the court has under the ordinary law, or that is a disputed fact have been investigation to evidence has to taken before the relief may be given petitioner, or that is the petitioner has not been asked a proper writ applicable to this case, in which case Supreme Court must be granted in a proper writ and if necessary modified to suit execution of this case. Generally only the person affected may move the court by the Supreme Court has held the social and public interest action. Any person who move the court, this is called expansion of the right to be heard in favor of public interest litigation. Following English and American decisions, the Supreme Court has admitted exception from the strict rule relating to the affidavit locus standi, and like in the case of class litigation classified as the public interest litigation PIL, where the public is general are interested in vindication of some light and enforcement of some public duty and other consequences which result from the guarantee of the Constitution remedy Article 32 in this. Not only in this remedy immune from being overridden by the legislature, but any law which renders nugatory or illusory by the Supreme Court power to grant in this remedy shall be void. This is the illustration. Remedies have been illustrated in the leading case of the A.K. Gopalan versus State of Madras, where the Supreme Court invalidated Section 14 of the Preventive Detention Act 1950. It is originally stood. The section was as follows: no court shall, except for the purpose of prosecution of for an offence punishable, article subsection 2, allow to statement to be made for evidence to be given before it for substance is the communication made under Article 7 of the ground on which detention order has been made against any person, or any representation made by him against such order, and notwithstanding anything contained in any other law, no court shall be entitled to require any public officer to produce before it. This is the disclose or the substance of any of such communication of the representation made proceeding of an advisory board or the part of the report of advisory board which is the confidential. It shall be offence punishable with the imprisonment for a term which may be extended to 1 year, or with fine, or with stood both any person disclose the public without a previous authorization of the central government or the state government, or as the case may be contents matter the purporting to this contents a financial communication represented as the referred to in subsection 1. The Supreme Court struck down the above provision on the ground that is the contravene Article 32 by preventing the Supreme Court from the effectively exercise its power under Article 32 following observation of Mahajan J. R. The illuminating. The section is in nature of an iron curtain around the act of authority making the order preventive detention. Constitution has guaranteed to a detained person the right to the told ground of detention. He has been given to right to make a representative right Article 22(5), yet Section 14 prohibits the disclosure of the grounds furnished to him or the contents of the representation made by him a court of law and mistake a breach of injunction punishable with the imprisonment. Now it is required clear that the authority passes as an order of preventive detention for the reason not connected with any action subject mentioned in the 7th schedule. The court can always declare detention illegal and release the detainee, but it is not possible for this ground to function if there is a prohibition against the disclosing the ground which have been served upon him. It is only by an examination of the ground that is the possible to say whether the ground fall within the ambit of legislative power contained in the constitution who are the outside its scope. Again, something may be served on the detainee as being ground which are not ground at all. In the contingency in the right of the detained person under Article 32 to move court for enforcing the right under Article 22(5) that has been given to real ground which is the detention order is based, the court would be disabled from the exercising its function under Article 32, adjudicating on the point that the ground given be satisfied of the requirement of subclause if it is not open to it to see the ground that have been furnished. It is a guaranteed right of a person detained to have a very ground which are the basis of order detention. The court would be entitled to examine the matter and to see whether the grounds furnished are the grounds on the basis of which he has been detained or they contain some of other vague or irrelevant material. The whole purpose of furnishing a detained person with the grounds is to enable him to make representation refuting these grounds of a proving is innocent in order that the court may be able safeguard of the fundamental rights and the grant him relief. It is absolutely essential that the detainee is not prohibited under the penalty of punishment to disclose of the ground to the court, and no conjunction by the law can be issued to this court disabling it having a look at the grounds. Section 14 creates a substantive offence if the grounds are disclosed, and it is also laid duties on the court not to permit the disclosure of such grounds. It virtually amounts to a suspension of a guaranteed right provided by the Constitution, insomuch as it is indirectly by a stringent provision makes the administration of the law by the court impossible, and at the same time is deprived detain the person from the obtaining justice from its court. It is my opinion, therefore, the section where the prohibit the disclosure of the ground contravenes or abridges the rights given by the part third to a citizen and ultra vires the power of parliament to that extent. There is provision of constitution. There is provision in the constitution for empowering courts other than the Supreme Court of the High Courts to issue the writs by making a law of parliament, but no such law has yet been passed, with the result that the no courts other than the Supreme Court or the High Courts have got the power to issue these writs. In extent of the several kinds of writs which or the Supreme Court and the High Courts authorize Constitution to issue may now the noted. A writ of habeas corpus is in nature of an order calling upon the person who are the detained another to produce the letter before the court. A writ of habeas corpus is the nature of an order calling upon the person who is detained another to produce the letter before the court in order to let the court now on the ground has been confined and to see the free. It is no legal justification for the imprisonment. The word of habeas corpus literally meant to have a body by the writ. Therefore, a court secures the body of a person who has been imprisoned to be brought before itself to obtain knowledge of the reason why he has been imprisoned and set him free if there is no lawful justification of the imprisonment. The writ may be addressed to the person, to any person whatever, as an official or a private person who is another person in this custody and disobedient to the writ to meet punishment to contempt of court. The writ of habeas corpus is thus a very powerful safeguard to the subject activist advocate not only the private individual but also the executive habeas corpus petition become the infrastructure of a detainee produced before the magistrate. The different purpose for this writ habeas corpus available may accordingly to stated to as follows. For the enforcement of fundamental rights, it is already been explained that under our constitution the right of personal liberty, the guarantee against the state by Article 21 to say no person shall be deprived of the life or the personal liberty except according to procedure established by law. Hence, if the executive has been arrested and detained any person without the authority of any law, or a contravention of the procedure established by law, which is authority, the detention of the law, which authorities and the imprisonment itself invalid or the unconstitutional. High courts and Supreme Court may issue a writ of habeas corpus against the authority which has been kept person custody and order of the release in the person under the detention. It also be issued before the order of imprisonment or detention in the ultra-virus statute with authority of the imprisonment or detention. The writ habeas corpus, however, not issued in the following cases: where the person against whom the writ issued or a person who is the detained is not within the jurisdiction of court. For secure the release of a person who is been imprisoned by a court of law on a criminal charge, to interfere with the proceeding for the contempt of court record by a parliament, where a person committed to jail custody by a competent court by an order with prima facie does not appear to be without jurisdiction or wholly illegal. Mandamus literally means a command. A demand has activity on the part of the body person whom the address in sort of command, the person to whom it's addressed to perform some legal or public legal duty which is be refused to perform, and the performance in which cannot be enforced by the other adequate legal remedy. It is therefore clear the mandamus will issue unless the applicant has the legal right to a performance of legal duty of public nature, and the party against whom the writ sought is bound to perform this duty. It is discretionary remedy that the High Court may refuse to grant mandamus where there is an alternative remedy for redress of an injury complaint of it. In the matter of enforcement of fundamental rights, however, the question alternative remedy does not weigh so much with the court, since it is duty of the Supreme Court or High Court to enforce the fundamental right in India. Mandamus will lie not only against officer and other person who are bound to duty, but no against the government itself. For Article 2 to 6 thesis provided the appropriate proceeding may be brought against the government concerned if the writ is also available against the inferior court or other judicial body, then they have refused to exercise their jurisdiction, thus perform their duty. The purpose for which the writ may be issued may not be now be analyzed as follows. For the enforcement of fundamental rights, whenever a public officer or a government has done some act which violates the fundamental rights of a person, the court would issue a mandamus restraining to the public officer or the government from issuing the order of doing act against the person whose fundamental rights has been infringed. Thus, where the petitioner who has otherwise eligible appointment of subordinate sub-judicial services has not been selected owning operation of communal rotational order, which infringes the fundamental right guaranteed by the petitioner. Article 16(1) of the court issued in order directing the state Madras to consider dispose of the petitioner application for the post of taking high law the merits and without applying the rule of communal rotational. Apart from this enforcement and fundamental rights, mandamus is available from the High Court for the various other purposes. To enforce the performance of institute to duty where a public officer has got a power conferred by the constitutional state, the court may issue a mandamus directing him to exercise the power in case of refuse to do it. The writ will also be laid the compel with person of performing his public duty where the duty is imposed constitution of the constitution of institute instrument. The compel in the court a jurisdiction tribunal to exercise the jurisdiction when it's be refused to exercise it. The direct public official or the government not enforced the law which is the unconstitutional court are the normally reluctant to issue any direction to government for the making of law. Mandamus will also be granted against the following person: the president of power or the governor of the state for exercise the performance of the power of duty in his office any under purporting to the done by him exercise performance those power and duties. Article 361 post. Mandamus does not against the private individual or body whether is incorporated not except where the state is collusion with such private party. In matter the contravention of the provision of the constitution over a statutory instrument. A writ of prohibition. A writ of prohibition in a writ issued by the Supreme Court or a High Court to an inferior court forbidding a later continued proceeding wherein the excess of jurisdiction or the usurp the jurisdiction with which it is not legally vested. In other words, In other words, the object of writ is to compel inferior court to keep themselves within the limit of their jurisdiction. The writ of prohibition differs from the writ of mandamus in that while mandamus command activity, prohibition command any activity. Further, the while mandamus is available not only against the judicial authority but also be against the administrative authority, prohibition as well as seriously in issued only against the judicial or quasi-judicial authority. Hence, the prohibition is not available against a judicial officer who is not vested with the judicial function. Where the excess of jurisdiction is apparent on the face of proceeding, a writ of prohibition is not a matter of discretion but may be head of right. In India, a writ of prohibition may be issued not only in cases of the absence or excess of jurisdiction but also in cases where the court of tribunal resumes the jurisdiction under the law, which itself contravenes some fundamental right guaranteed by Constitution. The Supreme Court can issue a writ only where the fundamental rights affected by reason of the jurisdiction affect the proceeding, though the provision seriously are the both issued against the court or a tribunal exercising judicial quasi-judicial power. Seriously issued the quest, the order or a decision or the tribunal, while the prohibition is issued the prohibit tribunal from the making of ultra vires order the decision. It follows therefore that while prohibition is available during the pendency of the proceeding and therefore the order of made seriously can be issued only after order has been made seriously. Briefly speaking, therefore, the prohibition of earlier stage seriously available at the later stage. The similar ground, the object of both secure the jurisdiction of the inferior court, tribunal, properly exercise, and that does not usurp the jurisdiction which it does not possess. The condition necessary for the issue of writ seriously are there should be a tribunal officer, legal authority determine the question affecting right of subject and having duty to act judicially. Such tribunal officer must have acted without the jurisdiction or in excess of legal authority vested, such the quasi-judicial authority, or contravention of the rule of natural justice, or there is an error apparent of the face of its three courts. The Supreme Court earlier took the view that the writ of seriously would not be issued against purely administrative action. It is issued only the authority has a duty to proceed judicially, that is to say, to make a decision after hearing a party is interested in the matter and without reference of and such extraneous consideration. But later decision have obliterated obliterated has distinction between the administration and quasi-judicial bodies. The current view is that even if the government institute does not require that before making an order affecting an individual, he must be heard. Such a requirement would be implied by the court, therefore, right of properly, so some other civil rights and individual is affected. To omit to do this is denied natural justice. Is in such cases the court may quash so-called administrative decision by means of writ of seriously under Article 226. A tribunal may be said act without jurisdiction to any of the following circumstances: where the court has not properly constituted, that is to say, where a person who is not qualified to sit the tribunal sat is the pronounced the decision complained against, where is the subject matter to inquire beyond the scope of tribunal according to the law created it, where is the court assumed the jurisdiction on the basis of wrong decision, in fact upon the existence of the jurisdiction of the tribunal depend, where there has been failure of justice either because tribunal has violated principle of natural justice, because the decision has been obtained by the fraud, collusion and corruption. When the decision of inferior tribunal vitiated by the inferior apparent of the face of the court, the liable of quash seriously, even though the court may be acted within the jurisdiction. Error in the context in Indians, error of law, where the tribunal state or the face of order ground on which they may be appears that the law these grounds were not such as to warrant the decision to which they had made. Seriously would issue the quash the decision. The writ of seriously would be not be maintainable where the High Court has however stated that the lower court had committed an error of jurisdiction or they had acted illegally, had improperly. In all such cases, High Court issue a writ of seriously to quash the decision, the inferior tribunal and the Supreme Court can also issue the writ in such cases provided some fundamental right has also been infringed by the order complained against. Quo warranto. Quo warranto is a proceeding where is the court inquiries into the legality of the claim which is party asserts to a public office and to oust him from the enjoyment if the claim he be not well founded. The condition necessary for the issue of writ quo warranto are the follow. The office must be public as the must created by the statute or by the constitution itself. The offices must be substantive one, not is merely function, not the enjoyment of the servant at the will during the pleasure to another. There has been contravention of the constitution or a statute of the statutory instrument. It is appointing such the person is that office. The fundamental basis of proceeding quo warranto is that the public has as interest to see the unlawful claimant does not usurp the public office. It is the however the discretionary remedy which the court may grant to refuse according in the fact of circumstances cases. Writ of quo warranto may be refused. There is the vexatious of where it would be futile in a result where the petitioner is guilty to leches or where the alternative remedy for ousting the usurpers, where the application challenges the validity of a appointment to the public officer maintainable at the instant of any person, whether any fundamental for the legal rights such a person has been infringed or not. A writ of quo warranto lies against the person who is the entitled to hold an office of a public nature and the only as a usurper of the office, such as the person is required to show by the authority be entitled to hold that office. The challenges can be made on the ground such as he does not fulfill the required to show by the authority be entitled to hold the office. The challenges can be made on the ground such as does not fulfill the requirement qualification of the sufferer from any qualities qualification departing from the hold such as office. A quo warranto lies upon the prominent of contrary to the statute provision. Quo warranto is just a very unlawful instrument safeguarding against the usurpation of public offices. The limitation quo warranto thus very usurpation of public offices. Thank you.